Maybe that's what made you good. But that was just dead this morning.
Hi, I'm David. Somewhere. Hi.
Nice to meet you.
Nice to meet you too. Oh, sorry, am I blocking?
Decide who you want to be and then just sit in that chair.
It'll be like those conferences where you present somebody else's paper.
Yeah.
Figure out what I'm actually gonna say.
Yeah, I know I brought up so many different things.
Yeah.
I'm like, oh, it'll just come together.
Yeah, I have the slides as a statute.
Yeah, great.
Okay, welcome everybody to our continuing Supreme Court series, our first of the year. It's Helsinn Healthcare versus Teva Pharmaceuticals USA. And anyone that was there knows it was a very spirited argument. And so we have a great panel today of 7 people. It's a large panel. And so we're going to kind of fly through the facts, but fortunately this is a very understandable case. And so what we're dealing with today is a drug called Aloxi, which is a drug that you take, it reduces the symptoms of nausea, et cetera, during chemotherapy. And so this is a drug that is patented, the patent is owned by Helsinn, who is the petitioner here. And Helsinn, for the interesting facts of this case, is Helsinn entered an agreement with this company called MGI. And it was before the 1-year period, the grace period. And the question here in this case is this agreement with MGI, is it a sale for purposes of the statute? And so Teva, who is opposing Helsinn in this case, they want to manufacture a generic of Aloxi, and they can't do that unless the patent is declared invalid. And so here's the statutory language we're dealing with. And it's pretty easy. It should be familiar to all those students of mine in patent law. It says the claimed invention was patented, described in a printed publication or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So today we're talking about this term, on sale, and what it means, and really whether the otherwise available to the public language modifies it or does not. And so today we have a auspicious panel. And so we're going to start with David Krinsky. He represents Helsinn in this case. And David, can you talk briefly about what your argument is and what you found interesting from the court today?
I think I got the microphone on. Oh, I have it very on. Anyway, as Professor Anderson indicated, I represent the petitioner in this case. My partner, Ken and Shanmugam, did the argument, so I had one of the most comfortable and the easiest jobs in the courtroom today, I think. But as he indicated, this is fundamentally a statutory interpretation case. Somewhat unusually among patent cases, it really does fit into sort of the mine run of Supreme Court cases where they take a statute Congress enacted and then figure out exactly what it means. And, you know, as is, I think, common in these cases, you know, that get review, you know, a lot of the difficulties about the facts have been sort of abstracted away. Everyone agrees, I think, that there was a sale in the sense of you know, something was sold for purposes of the UCC. I think everyone agrees, at least sort of for purposes of this argument, that it did not make the drug publicly available. But the question then becomes, well, what of this statutory language? The statutory does the phrase otherwise available to the public inform the meaning of on sale, and how does it do so? Our first argument is that the statute means what it says. When you have the word otherwise in a statute, that has to modify the terms that come before it. So public use is something public. On sale also has to be something available to the public, because otherwise the term otherwise doesn't mean anything. What gives this a little more interest, and I think gave some of drove some of the questioning today, is that of course the patent law isn't new. It didn't, the notion of on sale and the on sale bar wasn't invented with the America Invents Act, and so does that affect the result? And if so, how? Respondents argued that this, was an odd way to make a major change in the law, and you have 200 years of precedent saying that sales, so to be on sale, something doesn't need to be publicly on sale. We disagree with that. I mean, I think one of the main thrusts of the briefing that didn't really come out as much in the argument today, to some degree did, is are we really asking the court to overrule anything? And the answer is we're asking the court to overrule some Federal Circuit cases, but there certainly had not been, in our view, this clear notion that on sale could be public or private. And I think you saw the justices wrestling with that during the argument today. And then, of course, the further arguments arise from the legislative history, which you have sort of pointing in the same direction here, and from just the fact that trying to figure out whether there were private sales internationally, wreaks some sort of administrative chaos. This is one of the things that's interesting about the AIA is it I think tried, as I'm sure you'll hear from some of the other panelists, tried to bring the US patent laws into conformity with foreign patent laws. It also had the effect of making sales and public uses worldwide count as prior art. That's, I think, a slightly underappreciated nuance of the AIA versus the prior law, which said in the United States. And so now the question is, well, how could you possibly find a sale, analyze whether something was a sale in a foreign country in order for a patent examiner in the US to try to determine whether that an invention is anticipated. That's a tough burden to ask of both examiners and courts. So, anyways, a spirited argument. It's sort of an interesting case compared to some of the other patent cases the Supreme Court has taken recently, in that the Federal Circuit didn't articulate some bright line rule that came out of nowhere. This is a more traditional statutory interpretation case. I would like to think that they granted certiorari because it's sort of open and shut on our side, but I obviously have my own biases. But we'll see where it goes. It was I think a well-argued case, if I do say so myself on my team, but a very well-argued case by the other side as well. So the issues were nicely engaged, and we'll see what happens.
Great, and it was a well-argued and well-briefed case. Justice Breyer pointed out that both sides got their money's worth in the briefing, and I'm sure they'll be used.
He doesn't know how low our fees were.
I'm sure. David Zimmer, you represent the respondent. What was your main argument for why on sale isn't modified by these otherwise available language?
Sure. I mean, I think just quickly before getting to that, I mean, I think while they mainly focused on this otherwise available language, our argument very much focused on the phrase on sale, and sort of really focused on the idea that for two different reasons, there was no way to interpret that phrase as limited to sales that disclose the invention to the public. So if you look at just like what on sale traditionally means, or if you look up sort of the meaning in dictionaries, that it's not limited to public sales. The phrase can often be used in other contexts. And the idea that you could actually sell something even to one person without ever having placed it on sale, sort of doesn't, or at least arguably doesn't make a lot of sense. And then we also argued that just sort of that this term had it sort of was a term of art and had a very strong meaning that was not limited to sales that made the invention available to the public. And that was, that actually ended up being a decent focus of what the argument was about, was that issue. Because a lot of it a lot of that informs then, well, what do you do with this language that was added, this otherwise available to the public? I don't think there's any dispute that at least one purpose, whether it's the primary or only or whatever, one purpose was to add a new category of prior art, which is this idea of something like what's happening right now, which is a bunch of people, speaking publicly in a way that's not a printed publication, a patent, in public use or on sale, but that, if someone got up on a panel like this and disclosed an invention to a group of people, that would make the invention available to the public. So that's sort of certainly one thing that language was doing. And then what this case, ends up turning on is, does it also change the meaning or inform the meaning of these prior terms as well? And, our argument was obviously that it does not, and sort of in just sort of two quick reasons why. One is sort of that the word otherwise, it was sort of used to acknowledge with some overlap with the previous terms on the list, which obviously do, as David pointed out, involve a lot of things that do disclose inventions to the public, but it doesn't necessarily sort of compress the pre-existing items on the list to force them into conformity with this idea of being available to the public. And then the second point kind of gets back to why it's so important whether or not on sale is well established, because a lot of our argument turned on the idea that, well, if you were gonna take this well established term and change its meaning, this would be a very odd way of doing that. And I actually thought, just in terms of interesting things at oral argument, the government, which had taken, is generally on Helsinn's side, actually the government's attorney sort of agreed at oral argument that if on sale had an established meaning, to include secret sales, which they vigorously dispute, but that if it had that meaning, that they sort of agreed with us that otherwise available to the public would be an odd way to change that meaning. So a lot of it ends up I think a lot of how this case will come out will likely end up turning on what how established the justices think it was that on sale, is broader than just things that make things available to the public. And I think it's, it'll be interesting to see what they say. I think it was well argued. There were a lot of questions. And I think, it's very unclear what the result's going to be.
So I was counting votes, which is always dangerous to do, but I counted like 3 and 3. So it's tough to tell how this case is going to come out based on the oral argument, at least. Let me turn to Melissa Brand and then Robert Armitage. And you both filed briefs in support of petitioner. Can you talk briefly about what you added to petitioner's argument and why you felt that the petitioner had the best argument in this case?
Sure. So just briefly, I'm Melissa Brand. I'm at BIO. We represent over 1,000 biotech entities, including universities, both in the US and worldwide. And that is in part why we felt it was very important to support Helsinn here and below at the federal circuit. So we agreed with much of what Helsinn had to say, and I think we added some extra color to I think what was described as some of the underappreciated aspects of the case. And one of them was the fact, for example, that prior to the federal circuit's decision here and prior to the AIA, the on-sale bar was limited to the US, and that was by statute. And in enacting the AIA, prior art became worldwide. So now you have secret sales worldwide that can invalidate patents in the United States. And that is something that didn't exist before. And then really one of the questions that we focused on was, for what reason would Congress want secret sales abroad to invalidate patents in the US? So if you look at Supreme Court precedent and even a lot of the questions today, they talk about, well, what is the reason we have an on-sale bar? Well, we don't want inventions taken out of the public, fine. And we don't want inventors secretly profiting from their inventions and then applying for a patent only at the last minute. Arguably that existed in the earlier cases or not, but nonetheless, we talk about it that way. Well, what policy supports having secret sales by third parties in foreign countries eliminate patent rights in the US? Those US inventors or people seeking patent protection in the United States have no way of knowing what's going on in these secret sales. So it's not really a way that these inventors can conduct their activities. but it really will open up discovery and make things a lot more complicated in the US. So that's one of the things we focused on. Another issue that we focused on, and it gets a little bit lost, I think, and certainly wasn't really discussed today, was the strange procedure and posture below. So there was a panel decision that held that these sales can be invalidating, and then there was a petition for rehearing en banc. And in that denial, Judge O'Malley, who was on the original panel, concurred in the denial and did the first statutory construction in the case. And one of the things she did, without getting into too much nuance, is look at actually Section 102B, which uses terms like disclosure and publicly disclosed. And that actually was a really nuanced argument that I thought would get some airtime today. I know it was talked about by law professors in their amicus brief as well. So we took that on to really show why Congress actually very carefully crafted these sections to make it clear that prior art itself must be public, and showing how their use of the terms publicly disclosed and disclosure in 102B not only are not coextensive with the term prior art, but actually show really what Congress was trying to do. So those are the two, I think, substantive aspects. And then just lastly, but while I rant on, we did talk about how the types of transactions here in this case are actually incredibly important to biotech development. Most early stage biotech development is done by small companies. They don't have the type of capital that large companies do, so they often have to partner and engage in transactions of the sort that were at issue in this case. And when you have bad policy and bad decisions like this, it really throws into question how these types of transactions can proceed, what sort of patent certainty these small biotechs and ultimately their investors can have. And so that's something we really wanted to bring to the court's attention as well.
Robert Armitage, same questions?
Yes, I did an amicus brief on behalf of Congressman Lamar Smith. Congressman Smith was chair of the Judiciary Committee in the House of Representatives during the 3 Congresses it took to enact this bill into law, beginning in 2005, ending in 2011. He actually picked up on a National Academy of Sciences report in 2004 that recommended what I think anybody familiar with patent law would say would be astoundingly revolutionary proposals for changing the very structure of U.S. patent law. And in fact, what Congressman Smith and others on Capitol Hill crafted was probably the most uniquely different patent law from anything we've seen since at least 1793, when we arguably had what might have been a first inventor to file system. And so what Congressman Smith's brief did was attempt to explain part of the context, not legislative intent in the normal sense of looking at legislative history, which was not discussed at all in Smith's brief, but how this came about, the new statutory structure that was used that differed fairly dramatically from the statutory structure just on a nuts and bolts level from the prior law. And so when Congressman Smith looked at some of the principal arguments, for example, do the terms on sale have exactly the same meaning they did in the prior law? I think he scratched his head a bit and said, well, on sale appears, yes, in the new law. It also appeared in the old law, but so did the term prior art, which appeared in Section 103, the patent law section dealing with non-obviousness. Nobody would argue that prior art has the same meaning, even though the same words are used in both statutes. In fact, it was the intent of Congress that prior art change. You must look at the statutory framework. Another argument that was relied on by a group of law professors was the argument that the use in the patent law section in which on sale appears of the term publicly disclosed was evidence that Section 102 on sale meant something more than publicly disclosed, when in fact, I think as Bio did and Congressman Smith did, we carefully laid out why that term publicly disclosed was used as a synonym for what could and could not be prior art, including based on the on sale bar. The other, I think, interesting thing that Congressman Smith did was address the new terminology available to the public that had never been before used in the patent statute. That, by the way, did not come from nowhere. Congressman Smith pointed out that there are decisions of the Federal Circuit that equated the term known, that also appears in the patent statute, with available to the public. Now, the term known as used in the patent statute is a misnomer that has been in the patent statute since 1790. Since 1790, the word known has appeared when every judicial decision interpreting the word known has interpreted to mean publicly known. So there was a necessity to keep in the patent statute some term that preserved what's always been there since 1790, that public knowledge is prior art. And rather than use the misnomer term known, Congress used the term available to the public as an overarching requirement for public availability for anything to be prior art. And indeed, to have moved the United States from a first to invent system to a first inventor to file system, and maintain a secret prior art on use bar of the type we had would place us in a totally unique position globally, notwithstanding that as part of the statute, as part of the American Invents Act, as pointed out in the Smith brief, Congress was clear to say, we're doing this to harmonize our laws with international norms for patenting outside the United States.
Great, thank you. We have one amicus from the supports respondent. It's Charles Duan. He's with the R Street Institute. What was your argument in favor of respondent? Why did you think they had the better argument?
There we go. Thanks, Jonas, and thanks for hosting this panel, which has been really excellent so far. As Jonas mentioned, the excellent thing is a joke from the oral arguments, which I'm sure we'll get to. I'm with the R Street Institute. We're a think tank based in DC. We filed an amicus brief along with Engine Advocacy. They're a think tank organization that works with startup policy. The perspective that we took on this brief was to start with the question of this is a case about the on-sale bar, but why is there an on-sale bar in the first place? What's special about on sale that merits an additional term in the statute as it has for a long time? And I think the answer that we find is if you go back to principles of property law, sales are special things. Sales have always been treated as kind of the quintessential transaction of property, and the nature of sales is that one who sells something or one who offers to sell something is willing to cede all control over that item. What that means then is that the buyer is free to do whatever they want with it. They can resell it, they can use it, they can give it away for free. Now perhaps there's a contract provision such as a confidentiality agreement on the buyer. The buyer could break that contract, they might have to pay damages, but ultimately it's very hard to control the product once it's been sold. That makes sales particularly special, and what it means is that, in a sense, every sale is ultimately making something available to the public. This actually, I think, really reconciles the statutory construction problem, because you have a statute that says on sale or otherwise available to the public. The two constructions that are being proffered are, admittedly unsatisfying in some way in both directions. That on the one hand, we have to redefine on sale as only on public sale. On the other hand, that we have to treat otherwise as not meaning exactly what otherwise means. If we just understand on sale to mean it's automatically available to the public, the statute makes much more sense, and it really comports better with just traditional property understandings of on sale. So, that was the perspective that I think we tried to bring to the court. Now, did that gain any traction? At first, I didn't think so, but when I was reading through the transcript, some of the early arguments, there was a line of questioning from Justice Roberts and Justice Kavanaugh asking, look, if something's on sale, it doesn't really matter whether it's public or private. Sale is a sale, right? So I'm wondering if, if that may have been some indication that they were concerned with this idea that a sale should be really just a sale, and we shouldn't be adding sort of odd qualifiers to it. We did make a few other arguments talking about sort of the policy of the policy implications of allowing for confidentiality agreements to overcome sale transactions. So in this case, we had a confidentiality agreement between I think Helsinn and MGI. The argument was that by putting that confidentiality agreement on the transaction, that somehow the sale was no longer a sale. I think both we and the petitioners argue that, or we and the respondents argue that if this were to be ratified by the court, then it would be a simple matter for anybody to toss on confidentiality agreements onto every sale and thereby more or less overcome Section 102 automatically with pretty much all of the sales that they wanted, and that would have a number of concerning implications just given the way that we've seen, software and user license agreements and other sorts of contractual provisions on technologies. So that was pretty much what we talked about.
So we have two more panelists. Jim Crown, he's a counsel at AIPLA. You submitted a brief in support of neither party. Help us understand, for the students in the audience, why you would do that, first of all, and then what was your view about what way the opinion should go?
Thanks, Jonas. Well, all right, let me address first the issue of how we style our brief. And this is an ongoing discussion in AIPLA. But I think the bias that AIPLA has is to serve all of its members who happen to appear on both sides of the V. So that means that we try to address the legal issues in the case without any appearance of preference for the patent owner or for the infringer. And generally speaking, that results in a default position of in support of neither party. That is, we are not making a call about which party should ultimately prevail in the dispute, but trying to add our analysis of what the legal issues are and how they should be, those legal issues should be analyzed for some kind of predictability. So generally speaking, that will result in support of neither party. Which isn't to say that our analysis of the law doesn't also inure to the benefit of one side or the other. And I would certainly say that our analysis inures to the benefit of the petitioner here. So the approach that AIPLA took in its brief is more of a policy approach that rather than a narrow in the weeds statutory construction. We certainly engage in that. But what we tried to contribute was an explanation of the function of 102 in Title 35. And so the function of this statute is, number one, to identify novelty as a condition of patentability. But number two, to address the function of controlling the commercial exploitation of an invention before the applicant or inventor has actually applied for and disclosed the invention. So that's been a character of the patent law in the United States for a very long time, this concern that inventors may be trying to get the benefit of both sides of the bargain, keeping matters close and yet applying for this period of exclusivity when it suits them. So the 102 tried to address that before the AIA by essentially setting up a deadline for filing your application. And if you miss that deadline, there is a forfeiture of patent rights. There's no discussion. It's not a prior art issue. It's you miss the deadline, you're out. That kind of approach to this issue of essentially hiding your invention was addressed under the AIA by eliminating the forfeiture consequence of the patent where you fail to meet this deadline, and instead applying a prior art consequence to the sale. And the justification would be that in a first inventor to file system, you inherently have got an incentive to file promptly. And whether you suffer any consequences from your delay is addressed by the prior art result if you satisfy the criterion. Now, the criterion is for that we're talking about here, and I'm not sure the issue in the case is whether there was or wasn't a sale. I think the issue is whether whether there was the kind of a transaction that would create a prior art result. And that's where the issue of making a disclosure that is publicly available arises. It was frustrating at the oral argument to see them drill down into whether the series followed by the phrase otherwise publicly available was the deciding issue of the case. In our view, the deciding issue of the case is deferring to the legislative prerogative of determining what means should be used in order to accomplish the policy goals of premature commercial exploitation of the invention. And in this instance, Congress said, we will accomplish this goal not by patent forfeiture, but instead by applying a prior art effect where those inventions are otherwise publicly disclosed. And our position is also, because the amendment to the statute doesn't merely say the invention was patented, it says the claimed invention is patented. Our view is that this disclosure needs to be disclosure of the claimed patent, or at least one that would be obvious to a person of ordinary skill in the art. So I'll stop there.
Great. And last but not least, Patricia Campbell. She's a professor at Maryland. She did not submit a brief in this case. And so she is freer to talk, like a professor is, about how this case impacts more than just these parties as a whole. What implications does an opinion in this case have for patent law and innovation more generally?
Oh, thank you. So again, I'm a law professor. I didn't submit a brief for any party in this case. I've got no horse in this race, as it were. For me, this is really a teachable moment and an opportunity to talk to the students and the practitioners in the audience today. So why does this case matter? Well, first of all, I think that if Helsinn's position is adopted, it would just work a fundamental change in our patent laws. Not only would it be a big change, which isn't necessarily a bad thing, but a change that is really unexpected, not just by us as academics or as students, but by business owners. I think that when Congress used those words, patented, described in a printed publication, in public use, or on sale, it used words that we know. And I think that business owners had a right to expect that those words would mean the same things after AIA as they did before. We've long recognized that inventors have a choice. They can choose between commercializing their invention but keeping it secret, or they can make it public and get a patent. But you can't have it both ways. You can't have your cake and eat it too, right? And I don't think that fundamental policy has changed. If the court adopts Helsinn's position here, that secret sales aren't patent invalidating prior art, then think about what the implications would be. It would mean that an inventor could secretly commercialize his invention for some number of years, and only when he starts to get concerned that competitors are catching up, or starts to think that he might want to sue someone for patent infringement, does he have to go public and actually get a patent. And what happens then? Well, then the value of his invention is suddenly limited to 20 years from the date on which the patent application is filed. effectively, if Helsin's position is adopted, it's going to extend the patent term well beyond that 20-year period, and it's going to violate a long line of cases that we've all studied as students of patent law. Remember, the basic policies behind our patent system, what are they? We want to promote early disclosure of inventions. We think that that benefits the public because it enriches this public storehouse of knowledge. And not only do people get smarter, but it means that the next inventor can somehow improve on that pre-existing knowledge so that technology gets better and better. If we start to encourage keeping inventions secret for long periods of time, the public loses that benefit. I don't think that that's the policy that Congress wanted to support here. If Helsing's position is adopted, what happens? Well, it subverts that policy. It promotes secrecy and late disclosure. And those are two things that our patent system has long abhorred, and we've worked really hard to prevent. And I'm a little bit reluctant to say this, but what the heck. It almost starts to suggest that we could start to see something like submarine patents again, something that we thought we had moved away from. And they wouldn't be obtained in the same way, certainly, but that same sort of idea would come back into our system, that suddenly this patent would spring up and someone could be very unexpectedly sued. We've long recognized that prior art can be secret, but still have prior art effect. Think about those cases that you've read in your patent law class, where we have pending patent applications that haven't been published yet, but they have prior art effect on the date that the patent application was filed. Or we have so-called public uses, right, that are effectively secret, but we still treat them as being public. I don't think that Congress was attempting to convert the on-sale bar into some sort of an ultimate consumer test, like some of the parties have suggested, where an invention or a sale doesn't have prior art effect until the invention is actually available, on Amazon or at Walmart. I think we're looking at something that's much earlier in time than that. And furthermore, what's the broader effect here? Well, potentially, the decision that the court makes in this case could have a significant impact on other cases, like a case that's up on petition for cert right now, Ariosa Diagnostics. It's a different question. The question there is, what's the prior art effective date for unclaimed disclosures in published patent applications? Is it the filing date of the patent application, or is it the date on which that application was published? But think about the implications. If we say sales only count if they disclose the invention, then maybe disclosures in patent applications only count as of the date the application is published. I don't know, but it's a concern. So, what else? Well, I think that when Congress enacted the AIA version of Section 102, it was trying to expand the prior art, right? It removed all of the geographical limitations, and suddenly things that happened abroad count as prior art. They don't have to take place here in the United States. And Congress included this new language that we didn't have before, otherwise available to the public. I think they were trying to capture all sorts of events that previously were in a gray area. We didn't know whether they were prior art or not. Things like the Klopfenstein case, where somebody goes to a conference and displays a poster for a couple of days. There's no printed publication. Nothing's on sale yet, but we have this graduate student standing up and giving a presentation and talking about what he invented and providing a significant amount of detail about it. I think they were trying to capture those kinds of things and say that's prior art now too. Well, in an even broader case, why is this case important? Well, I think we have to recognize that our patent system is a one-size-fits-all system. It doesn't discriminate based on the size of the inventor, aside from, some reduced fees, right? The same rules apply to multinational corporations and to little individual inventors who just tinker in the basement on Saturday morning. But we apply the same rules to all of them. And we apply the same rules to pharmaceutical inventions, to software, to electrical products, even though those kinds of inventors or those kinds of inventions might have different interests. Pharmaceutical companies, their products have value for decades to come, right? And they would like to extend their monopoly as far into the future as they possibly can, because that lets them keep their competitors out of the marketplace, and it lets them recoup those huge investments in research and development that they had to make, even though they still have the same 20-year patent term that applies to a software inventor whose invention may not even have any value by the time his patent actually issues. So I think the case highlights for us once again that the same rules apply to everybody, even though sometimes they may work inequities. Here, Helsinn would like to have a longer patent term, but unfortunately, that may not happen because there's been an on-sale bar.
Great, so that's the whole host of opinions on this case. And there were some more. There were some excellent briefs submitted by other people who don't appear on the panel as well. So let me invite anyone that wants to ask a question to come down to these microphones and ask a question right over here.
Is it on?
Yes.
Okay. Justice Breyer asked a question to petitioners that suggested this case could be decided under the experimental use exception or another exception to 102. I was wondering if there was any daylight that you could see in the court not addressing the statutory interpretation that we all been talking about.
I'll say a little. I think that I think that Justice Breyer was under the impression that a lot of us are, that if you look at the facts of the transaction that occurred, it's not really clear why this is a sale. There was no product that was actually sold. There were a whole bunch of contingencies attached to it. It's not totally clear why a sale occurred or why it was held to be on sale. Nevertheless, that was not an issue at the petition stage, at the Supreme Court stage. I think the Federal Circuit found that there was a sale. So I think that he was really just trying to clarify sort of a factual oddity of this case, but I'm not sure it has terribly much bearing as to the question that's being decided.
One other point, there may be no experimental use exception that survived the American Invents Act. And indeed, the premise that the on-sale bar, as it was formerly known, requires availability to the public actually would eliminate any justification for continuing to apply the traditional on-sale bar.
If I can just highlight an ongoing point of confusion, even in the Federal Circuit. The expression on-sale bar is a term of art that actually applies to forfeiture. And the AIA was intended to abandon the concept of a bar, that is a forfeiture, and instead apply a prior art consequence of failing to satisfy the 102 condition.
Real quick, sorry to jump in, but you guys understand this better than I do, but the transaction, we talked a little bit about that, was between Helsinn, a foreign company, and a U.S. potential future maker of the product. Is that right?
A distributor, a potential distributor, yes. But the drug was not yet approved at that point.
Right. So they had not yet actually made it, and they had not yet actually built the factories or changed or retrofitted the factories to build it, correct?
I don't know that that's in the record. I don't know the details of how far along they were in terms of building factories, but I do think it is an important point here that this was, one way of structuring a transaction to provide development funding. And it is, one thing that I think we tried to bring out in our briefing is that it's a little bit of an odd outcome to say, well, this transaction is prior art because it was structured as a sale transaction in that MGI, the distributor, agreed to buy drugs to sell in the United States in the event of approval, whereas you could have had largely the same commercial consequences and the same level of availability to the public if it had been some sort of joint venture partner that didn't tie the influx of funding to a sale transaction. I think that's an important observation.
Dennis?
Just ask us to use the mics for the webcast.
Okay.
Please.
the ball was pretty settled on that issue. But
It's on. No, it's okay. Just start. Just keep going.
I thought that was kind of interesting, and then Kavanaugh follows up and says that this is pretty much, if the law wasn't settled, we got the government's attorney to concede that this is a pretty fumbled attempt at overturning what would have been settled law. Kavanaugh says, yeah, this is a fundamentally flawed attempt at clarification, and then we kind of move into, so it seems like that settled area of law question is important, but then we go on this tangent of, well, then what do we do with otherwise? And we get a brownie hypo. So I was wondering whether you could kind of help me understand whether that was helpful. It seemed like it actually confused counsel for Teva as well. And then the one quick follow-up question of what do we make, if anything, of Justice Gorsuch's question about what do we do with, or what weight do we give to the PTO's interpretation?
Anyone want to take the brownies?
I can take if I remember that, I mean, I guess you could pull up, but I think the question was basically something like, imagine someone tells you, you can, please don't bring for dessert a pecan pie. What was it?
Peanut butter cookies, pecan pie, brownies, or any dessert that otherwise contains nuts.
And I think what the question was getting at was the idea that, would you feel comfortable bringing a nutless brownie to the, in response to that. And I think there was some confusion. I think that a lot of the confusion came down to like how you conceive of a brownie, and like how, if you sort of view the inherent nature of a brownie as containing nuts, which is I think why it all kind of fell apart, because like obviously the question of what a brownie is kind of irrelevant to.
I would like to state for the record that I believe I have personally served nutless brownies to Willie J. I just need to put that out there.
Yeah, well, yeah. I mean, so I think what he said is that you would not bring a nutless brownie. Although I think he kind of backed down from that a bit. But I mean, I think the idea was getting at like, if you think a brownie, the concept of a brownie is broader than just, something that has nuts in it, then how does, isn't that analogous here? So I think that's sort of what that was getting at, and sort of why there was that, why I think Justice Kavanaugh then jumped in to say, I think your position, you have to say that you would not feel comfortable bringing a nutless brownie to this hypothetical dinner party.
In some ways, that kind of a question is useful, set aside the brownie issue, but the element that follows the word otherwise in most syntax is an element that defines or describes a characteristic held by all of the preceding. So in that example, for example, otherwise contain nuts, the implication is that nuts are the problem as they occur in any one of the preceding elements. And as it applies here, the implication is that publicly available applies to the preceding elements that are listed before the word otherwise.
So
Right, that's a, oh, go ahead.
I feel like the thing about this case is it is the worst possible situation for statutory construction. There are two options for construction at issue, neither of which is perfectly satisfying. The legislative history points in every possible direction. The history is, according to one party, ambiguous, and according to another party, completely unambiguous. It's very hard to tell what to do with this sort of thing. I kind of wish that John Duffy had shown up, because I cited an article of his that cited a famous article by Judge Easterbrook called Statutes Domains, in which he notes that fundamentally this is a problem of statutory interpretation, that when you're talking about a body of 538 people, they're not all going to share the same view of what the language means. What do you do with that in that situation? His answer was to take things very cautiously, to basically let, construe the statute as plainly based on the text as you could. There are a variety of different approaches, but I think that really, this case really highlights just how hard it is to do statutory construction when you're talking about a collegial body where, they may not all have the same concept of what's going on.
Hi there, Dmitry Karstad, professor of law at GW. I teach patent law, and nice to be back at AU as well. At the risk of overcomplicating the statutory interpretation question, a couple more points maybe related to what some of you said. Justice Kagan briefly asked, are third-party secret sales patent barring? And the answer was yes, and I think that answer is correct. What is the significance of this question? You mentioned forfeiture, but the statute, the older, the new version, actually doesn't distinguish between first and third parties. And I was surprised the court didn't pick up on that, except for Justice Kagan's question. So what is the significance of a third-party secret sales here? It's not just about the inventor and the policy. The policy of patent term extension isn't really reflected in the statute in this way. The second question, maybe going off what Charles said, is the Nocitura Associates argument. When I looked at the list of terms, again, patents are open, right? Publications, public use, sale, and otherwise available to the public. What do you make of the fact that public does not precede the word sale? And isn't it a potential reading, at least, that a sale is deemed to be a public event by definition? So I'm just wondering what you think of these two statutory arguments, especially given Nocitura Associates was an important canon here as well. And I think those arguments again kind of tilt to both sides. The lack of first third-party distinction and the fact that a sale doesn't have a public modifier, what public use does, and whether these might be significant in an argument, especially given what Justice Kagan asked.
Well, maybe I'll go ahead.
Yeah, so I'll quickly, I think this ties into the last question too. So I think what the examples that were given with the pecans and what have you show that the statute's ambiguous, arguably. And so then you move to other parts of the statute, and I think that's what Dimitri's getting at. When you look elsewhere in the statute and you think about how each interpretation would affect things like, okay, suddenly now we have secret third-party sales worldwide that are going to invalidate perfectly innocent inventors' patent here in the US. Is that something Congress could have wanted to do? And I really don't think that that's consistent when you look at the overarching goals of the AIA. One of the things they really wanted to do was to make prior art more predictable, something you could easily judge and know, okay, yes, I can apply for a patent and have a good chance of getting it, or no, I won't. And it's really important for businesses that way too, right? They have to be able to order their affairs knowing they have a pretty good shot at protecting their inventions or not, and then they invest accordingly. So I think that is one thing I was a little bit disappointed that I didn't think the justices got very much into in the argument today. I think it's well briefed by some of the parties and amici, but I think it's a hugely important issue, and maybe we'll see it more in the opinion.
And if I could just jump in and respond on the first question, I think the question about whether third-party sales should be considered to be invalidating sales, I think illustrates how the purpose of the statute and the contours of the statute aren't necessarily the same thing. I mean, I think our view would be that one motivation behind treating sales as prior art is to make sure that people aren't out there commercializing their inventions ad infinitum before they patent them. That's much less of a concern now, I would argue, under the American Invents Act, where you may lose your patent right if somebody beats you to the patent office in a way you couldn't before. But I think everybody agrees that third-party sales to the public are invalidating, just as sales by the inventor are. And so it can't be the case that the only purpose of the on-sale language is to sort of cause inventors to forfeit when they commercialize, and that can't really answer the question of where does it end.
And just one more thing to throw on to the end. I think Justice Alito had a very good example that he gave where he said, what if the statute said patented in a printed publication, on sale privately, on sale publicly, in public use, or otherwise available to the public? His point was, and I think most everybody agreed, well, that would make no sense. You don't speak in English that way. And so he used that as an example of how on sale, when tied in with the word otherwise, must mean on sale to the public.
If I can just add one more small piece. The position that AIPLA has is that metallizing did not survive the AIA, and that the Congress made a policy decision balancing all of the conflicting interests that it is more important to have disclosure than it is to have forfeiture.
And by the way, a continuing incentive to disclose, which of course is totally destroyed if secret sales become prior art. And in this case, it's a classic example of where there essentially was no commercialization, period.
Well, one thing to bear in mind about this statute, which I think got lost in some of the discussion today, both at the Supreme Court and maybe at this panel, is that there's really two different kinds of acts that can lead to something being prior art. One is making the idea public, making the invention available to the public in the sense that people are able to add it to the store of public knowledge, and the other is people being able to go out and buy it. One reason I think why the on-sale language is important, however this case ultimately comes out, is that there's a sense in the law that if people can go out and buy a product at the corner store, it can't very well be in the prior art, even if it's impossible to reverse engineer. I think that's something that is totally consistent with the notion that it should only be invalidating if it's in fact available to some relevant public, as opposed to being something that was sold but only behind closed doors in a private transaction, perhaps with confidentiality agreements, in a way that doesn't really make the invention available, part of the store of both public knowledge or things you can go use.
I just quickly on that, I mean, I think that's, one of the tricky side of that is how you, where do you actually draw a line there? Because, if you're saying, if you're trying to sort of just draw a line somewhere between, a single sale protected by a confidentiality agreement and available at the corner store, there's obviously, a million places in between where you could say, well, now it's available to the public and we're not. And so I think one of the things that the court may or may not get into, depending on things that really we don't need to get into about forfeiture and whether they want to reach certain things or remand them, but is sort of like, okay, let's assume that it is available, it does need to be available to the public. What does that mean? And this sort of gets to Charles's point as well, is like maybe there's a sense in which just a sale period makes it available to the public in some sense. So I think that there's sort of a lot going on, even if you assume that it does sort of modify back to on sale.
So, get a little bit off task. So I'm Rob Stern, and I spend a lot of time, as some of you know, at the PTAB. And as you probably know, the post-grant review process applies to AIA patents, those filed after March 16, 2013, and it includes all grounds for invalidity, including what we're talking about here. And what really concerns me is the Patent Office's ability to handle this kind of prior art as a practical matter, because how are you going to prove in these proceedings, these PGRs, that you have something that was, whether it's public or private, outside of the United States? There's no discovery in PGR. And from the point of view of a patent owner, this could be very pernicious, because you bring a lawsuit and all of a sudden you have a PGR lodged against you and your patent rights are under this cloud. And I can tell you the PTAB is not going to know how or why to deal with this. They just will, this is going to go into the stratosphere. So, I realize that I'm talking about something that sounds very obscure, but when the AIA was put into effect, nobody in the pharmaceutical industry, for example, expected the PTAB to be a problem. And in fact, the most important PTAB cases right now involve the pharmaceutical industry. So this case, no matter how they come out with this, is going to have huge impact from a real-world perspective.
Congressman Smith pointed this out in his brief, and just as an example, the real issue is how do you counter a fraudulent claim that two of your foreign competitors had a secret sale between them and it validates your U.S. patent in a proceeding built on affidavit evidence and limited ability to discover and depose otherwise. I think if anyone had thought who was involved with the PGR proceeding that Helsinn wouldn't be successful in this case, you could hardly have justified the PGR procedure the way it's currently structured.
just want to add, I agree with that, and I think this is consistent with an overall trend. We see I'm on the Hill a lot, I'm at a lot of conferences, and just, I think a lot of what Congress intended with the AIA, they wanted to make it clear what your prior art would be, they wanted to have fast proceedings at the PTO, and if your patent survived, you would be able to be more confident in it. They wanted to lower the cost of litigation. And decisions like the federal circuits, if it's affirmed here, it's going to complicate the post-grant proceedings even more, like you said. It's going to drive up discovery costs and litigation, and it's going to add more uncertainty, as I said multiple times now, as to what can be prior art to your patent, and you can never really be sure what you're doing. And I think we're just overall seeing a big trend that suggests that what Congress wanted to do with AIA is just maybe not coming into fruition. So I agree, Rob.
I'd say more, but I know this guy's been waiting for a long time.
I guess maybe because it kind of got touched on a few times. I think to some degree.
You want to come, Mike?
I'm a student here as well, and I think to some degree, I think I might fall somewhere between you two there, right in the middle, because it seems like you can't have a sale without somebody else knowing about it. Nobody sells something to themselves, right? So whether or not there's been enough there to get to the relevant public or enough to somebody else, I think it goes back to the idea that there's ideas can still float away too. So even if it's not out there to the whole wide world, the fact that we know about it, it's not really secret. And the fact that there's somebody knows about it, there's still information out there. So I feel like there's some sort of divide there that I maybe just don't wrap my head around. I don't know. You guys have something.
When Congress wrote this new statute, they jettisoned in section 102 the word invention, and the term used is claimed invention, which is actually a defined term. Claimed invention means the subject matter defined by the claim. So it really must be that the sale makes available to the public the actual limitations of the patent claim, in this case, the actual formulation. So what the it is under the AIA is very clear, whereas under the prior law, what the it was when you use this term invention that doesn't have a clear meaning, it wasn't so clear.
So I think this gets back to a debate that went on through the Supreme Court argument over what the rationale is for the on sale language. So Petitioners Council kind of went with this language of the predominant purpose is to ensure that the storehouse of knowledge is, that one cannot take away from the storehouse of knowledge, and received a number of questions, I think, from Justice Breyer and other folks saying, well, isn't there a second rationale of ensuring that the patentee can't commercialize and then gain the benefit of a patent after having commercialized for a number of years? And the argument continued as to which of those rationales was the more relevant one. I think that some of the arguments that Mr. Shamuga made were that those rationales came up mostly out of the learned hand metallizing decision, and they weren't really ratified. But then the Benino Boats case came up. Justice Breyer asked about that. So I think it'll be interesting to see which of those rationales ends up really being the one that the Supreme Court thinks drives the existence of the sale issue. I would hope, having written the amicus brief on this, that the property issues do come up in that, insofar as you mentioned, when somebody sells something, it is out there in a sense. It seems to me that that's a very good line to be drawn in terms of what is public and what is not. And it seems to be that Congress put it into the statute, so that would seem to be good reason to follow it.
Well, I'll just add very quickly, I think that the question of what is available to the public may, regardless of how this case comes out, present some interesting line drawing problems that have yet to be fleshed out in the case law. This is just as a civil procedure point, that wasn't before the Supreme Court today. The question is, if you have a sale that is not available to the public, is that enough? But that sort of, that assumes the answer to, I think, some of the questions people are rightly asking about other cases and the broader policy interests.
Here we have time for one more question.
I think Professor Campbell made a really interesting point about how if this decision is made in ruling for the petitioner, it could definitely extend it could potentially extend the patent rights for the term to go past the 20 years. For those in support of the petitioner, I would like to hear what your thoughts are, if you feel like that could be an issue. If it is, are there any other measures in statutory language that you think would combat that, or any other things that you think would, I guess, deter this from becoming an issue? Because I think extension of the term is a huge issue that I think anybody under patent law would have a problem with.
Well, I think very briefly that the very structure of the AIA and the fact that we now have a first inventor to file system largely mitigates that concern. The notion that you could wait deliberately and only file a patent application later in the hopes that you'll get some more patent term on the back end 20 years later seems to me to be a tremendous risk if you're an inventor, particularly in a fast-moving field where someone else may come up with the same thing. So I'm just not sure how realistic a problem it is in practice, although I certainly understand the sort of policy concern. The other observation I'd make in response to that is just that I think everyone agrees here that a sale, if something really is available in the sense of being traditionally commercialized, so that you're making boatloads of money selling your latest greatest new iPhone, that is patent defeating even under petitioner's reading.
Sure.
What's a single buyer?
I think, well, I think that's directed at me. I think that has to depend on the specific facts of the case. I mean, a true single buyer market seems, a little theoretical. I don't think that.
Intel selling their chips only to Apple, or the maker of an airline plane, Boeing, selling them only to the U.S. government. It happens all the time where there's a single supplier-supplying relationship, right?
Yeah, and I think that that goes to one of these questions for a future case is when has a sale really been made to the relevant public? I do think that's a potentially hard line drawing problem, and if you have a small market with a small number of interested buyers, I mean, I think it's somewhere along the lines, I think in one of the briefs, there was an example given along the lines you're suggesting, maybe not with one buyer, but with a small number of defense contractors. You have, Lockheed Martin and Northrop Grumman are the only possible interested buyers. If you sell to both of them, haven't you made it available to the public? I think the answer in some cases may be yes. I don't think that's the situation here.
All right, I think we're out of time, unfortunately. I think there's food and drink out in the outside. Is that right? Okay, good. So please join me in thanking my excellent panel for their work today.
I want to talk to you. What did you think the drug deal. I want to. Yeah, so I was just looking. And then I responded being like, hey, I'll do a fine interview this time, da-da-da. Never got back to me. What's up, Melissa? Alright. Find engagement with parts of yeah. Yeah. Steven is going. Are you studying?
I only have one.
You know, it's interesting.